So before we move on into the lectures on functionality, I want to offer a few takeaways from our discussion thus far about trademark distinctiveness in regards to trade dress. One of the key things to emerge from these cases is just how interconnected the doctrines of trademark law are. That when deciding whether or not a kind of mark should be distinctive or not, the Supreme Court often finds itself looking to other doctrines like functionality to say that, okay, if we allow this kind of mark in, and there's a prospect of a meritless suit designed to stifle competition, how confident are we that the functionality doctrine is going to cut it off? And in 2 Pesos, you see the court sort of saying, yeah, it'll be fine. In Qualitex, you see the court saying, yeah, that'll be fine. In Walmart, you see the court being a little bit more circumspect about the possibility, realizing that competition can be deterred not only by a valid suit, but also by a meritless suit, one that is brought to deter competition by imposing costs on upstart competitors who may not have the funds to fight out that kind of litigation. Note also that when we looked at the Booking.com case, another doctrine that kind of comes into play is anticipation of how things shake out at the level of liability. When you actually apply a likelihood of confusion analysis, how confident are we that down the line courts are going to get that right? And we adverted to this idea that when you're allowing a mark to be recognized as being distinctive, as for example when we're dealing with the Bacardi O, that we can say that, oh, the scope of this particular mark is not going to be that broad. And when we look to the likelihood of confusion analysis, that kind of mark is not going to be deemed to kind of capture that many equivalents to it. That you're going to have to get to be really close to the actual mark before a court would say, this is something that is likely to cause confusion. But as we talked about in that lecture, you're expressing confidence that courts are going to remember or understand that this is not a broad mark, this is not a thick mark, but this is rather a relatively thin one. And again, there's this interplay. And the more open distinctiveness is, the more open you are to trademarks, the greater pressure you're putting on these other doctrines. Some other basics, just at the level of doctrine, things you can rely on. Packaging versus design. Product packaging, trade dress can be inherently distinctive, and then depending on what jurisdiction you're in, you follow the spectrum of distinctiveness, or something like the Seabrook test. Product design, trade dress has to have secondary meaning to be protected, and when in doubt, 2 Pesos notwithstanding, you should assume that a piece of trade dress is product design, not in packaging. The role that functionality plays in shaping doctrine on trademark eligibility. It's the doctrinal justification for expanding trademark in 2 Pesos. It's the policy justification for curtailing trademark protection in Walmart. This recognition of the importance of protecting competition in useful terms and the concern that we may have frivolous suits. In these cases also is woven in questions of judicial policy. And so considerations favoring the secondary meaning test in Walmart, not necessarily being about what is the right answer at the end of the day, or whether or not we think courts get to the right place at the end of the day, or what is the right substantive outcome at the end of the day, but rather the ability of courts to get rid of non-meritorious suits at an early stage. So we have considerations of administration. Recall, though, in the more recent case of Booking.com, the court is less concerned with those issues, or is less sensitive to the concerns raised by the Patent and Trademark Office, that is a reason for skepticism of generic .com kinds of trademarks. We also have what I think are very interesting questions about the judicial role in trademark law. And I think what I'm about to say can be said about any number of doctrines of law, but trademark is one of them at the very least. And when you're in law school, and you're studying law and you're thinking about judicial philosophies of originalism versus non-originalist theories of constitutional interpretation, or textualist theories of statutory interpretation versus those that place a greater emphasis on things like legislative intent, legislative history, policy considerations, etc. It's very common for people to talk about these issues in public through the prism of very high-profile, politically charged cases. And I find that it's very hard to have analysis of these theories of statutory or constitutional interpretation in a manner that is detached from the underlying substance. So if think in the administrative law realm, can the president issue rules under the Clean Air Act to address emissions of carbon dioxide? Obviously, the effects of human-caused climate change are politically and socially extremely important. And it's very hard, or your mileage may vary, I find it very hard to read opinions talking about those issues in a way that is detached from the underlying substance, whether or not we are going to do something about climate change. And so one of the nice things about trademark law, to my mind, is that important or interesting as it is, it doesn't provoke these kind of left versus right fights that I think often obscure questions of statutory interpretation or theories of statutory interpretation. Now, of course, some people would say that's because there are no real debates about statutory interpretation. All this stuff is politics, and maybe that's right. But I think there are, at the very least, whether that's true or not in the hot button issues of public debate, that is not true of every area of the law. And there are areas of the law where you can see these debates play out in a way that lack the political charge of the more traditional places where lay people or non-lawyers discuss this kind of thing. And so the issue in the Lanham Act, or one of the issues presented by the Lanham Act that I just think is very interesting from the perspective of what is the proper judicial role in implementing statutes, is the fact that the Lanham Act, the statute regulating trademarks in the United States, has a lot of open text. For example, likelihood of confusion, the standard of liability. Well, how likely? How many consumers? And for purposes of what we've been discussing in recent lectures, the vast amount of matter that may function as a trademark, any word, name, symbol, device, or combination thereof, and the statute's lack of standards for trade dress. And so we have this question of what are courts supposed to do when they fill the gaps of the statute? What ought to guide them? And so one possibility that I alluded to in an earlier lecture is the common law backdrop of trademark law. And so this idea that the common law required secondary meaning for trade dress, and that perhaps we should apply that rule when we're dealing with trade dress under the Lanham Act versus, say, starting from scratch. And so that's one possibility. Or do we, and reading statutes against a common law backdrop, that's a common move. And so, think about something like copyright law. They have a case that, tries to adjudicate what is the scope of the work made for hire doctrine. And the work for hire doctrine, the copyright belongs to the employer. If a work is made by an employee acting within the scope of employment, how can you tell whether or not someone's an employee or not? When this comes up to the Supreme Court, they say, oh, well, just look to the common law of agency. We assume that Congress is writing against that as a backdrop, and we go from there. Now again, 2 pesos reaches a result inconsistent with that approach. Walmart, though, is more consistent in that regard. And so, one possibility, we went through some of these last time, we can look to the common law backdrop, we can try to suss out an answer from the statute, we can look to policy, we can look to in other words, looking to the consequences of what happens, we can try to appeal to some larger vision of what the purposes of trademark law are, et cetera, et cetera, et cetera. And so my point here isn't so much to say that there's one particular view or not that ought to carry in these cases, although I actually do think that 2 pesos got it wrong by not looking to traditional trademark understandings, the kinds of things that judges had sort of pounded on over the years, and then Congress chose not to upset, and then there's an issue with the law of trademarks evolving in a different direction without congressional approval, but Congress gave its approval in the end, so that's that. My point again isn't to argue in one direction or another about these particular debates at the moment. My point is just to say that one of the things that's interesting about doctrines like trademark law is you can see these debates at work in an area where we don't have the underlying really polarizing political fights that we do with other bodies of law where we normally talk about this stuff. If you're interested in things like statutory interpretation or the judicial role in interpreting and implementing law, trademark law is a good place to see those theories in action. Thanks very much.